economy. What really matters for investors and interest.
Hello and welcome to Bloomberg Quint. You're watching Insolvency Diaries. The case of Essar Steel's promoters brings to mind the imagery of a boomerang. Every time courts dismiss their case and move the insolvency process forward, they find a way to come back. This time, the Supreme Court's recent ruling in Ruchi Soya's case may infuse fresh life in Ruias family case before NCLT Ahmedabad. Three erstwhile directors of Essar Steel, including Prashant Ruiya, are now arguing that they were selectively allowed to participate in the creditors committee meetings, and so any decision taken by the creditors committee without giving proper notice or adequate participation to the suspended board will have to be set aside. They're also arguing that they weren't given a copy of the resolution plans that came in for Essar Steel. And this, the directors are arguing, would include the resolution plan submitted by ArcelorMittal. And so, the resolution plans for Essar Steel need to be deliberated and voted upon afresh. For all these asks, the three directors have relied on the Supreme Court's recent ruling in the Ruchi Soya case. In this case, the Apex Court has held that members of the erstwhile board must be given copies of the resolution plans and they must be allowed to participate in all the meetings of the creditors committee. Only those directors who are related parties of the corporate debtor can be barred from participating in the creditors committee meetings. Since this process was not followed in the Ruchi Soya case, the creditors committee has been asked to deliberate upon and vote afresh on the resolution plans. So, will the Ruchi Soya ruling give a fresh lease of life to Ruias case? To answer that, I have with me well-known insolvency lawyers Pooja Mahajan and Sitesh Mukherjee. Pooja, Sitesh, welcome to Insolvency Diaries. Pooja, I'll come to the merits of Essar Steel's promoters case in just a bit, but before that, has the Supreme Court opened a Pandora's box by laying down that the erstwhile board must be kept in loop for everything, so much so that if you don't do that, the process will have to pretty much start all over again?
Good evening, Payaswini. I think you're absolutely right. They have opened a Pandora's box, and I really don't know where this will actually lead to, because we've already seen cases where directors are now coming back and asking for information about the resolution plans. My worry is what is going to happen to cases where COC has already approved these plans. So you will find promoters, ex-directors, suspended directors filing applications in court saying, please give me a copy of the resolution plan, let me read it again, let me give it back to the Committee of Creditors to reconsider, and what this will lead to is inevitable delay. And you will find resolution applicants really getting frustrated with the process at some point in time and saying that this is really leading to nowhere. So yes, that's one issue which is clearly there. So there's going to be you can expect some delays in cases where directors will file these applications. The other issue is also going to be around the conflict of interest. So there may be cases, where the directors themselves or the promoters themselves may have filed resolution plans, and then the question of conflict of interest would come in those cases. In those situations, is it fair to really give the resolution plans to the directors and let them comment on the resolution plan when conversely the same right has not been given to the other applicants? So I think these two are the big issues which are really going to, we'll see some action around these two issues in coming months.
Okay, I'll dwell on the conflict part in just a bit. Sitesh, let me come to you. How are you looking at this? We've seen promoters use every trick in the book to hold on to their companies. Now, with this outcome in the Ruchi Soya case, do you anticipate promoters themselves or through, let's say, these erstwhile directors on the boards finding reasons to scuttle the IBC processes? For instance, say that we gave an X and Y input to the COC, but they didn't consider it, and now here we are before you, the NCLT, and you must hear us.
So I don't really apprehend that this is going to unduly delay the insolvency process, or that it is going to open some kind of a Pandora's box for existing processes where the suspended board of directors have not been fully informed of the resolution plan. I think what the Supreme Court is saying is that there is one more source of input which the Committee of Creditors has, and in forming its judgment, it should give an opportunity to the suspended board of directors to provide the input on the resolution plan. That is it. So I suppose once the input is given and the Committee of Creditors has considered the input, then the wisdom of the Committee of Creditors, the commercial wisdom, would be allowed to prevail like in many other cases. So really speaking, I don't see this as a big opportunity for promoters to hang on to and delay the process of insolvency.
Okay.
Insofar as the existing cases are concerned, those which have already been decided, I don't think this judgment will give them the fresh lease of life if the insolvency has already been approved. But in cases where the plan has been approved and may have been pending approval of the adjudicating authority, there is a possibility that the Committee of Creditors may have to hold one more or two more sittings to hear the directors on the plan and then decide whether they want to continue with their decision that they have already taken, or they want to, alter their voting pattern as a result.
Okay, all right. So you're saying in cases where the NCLT has already approved the plans, in those cases, you don't see this, Ruchi Soya ruling giving grounds to promoters. But a majority of the cases that you're talking about, at least, the big 12 ones, not in all of them, only from what I can recall, 2 or 3 of them, the NCLT has approved the plans per se. But in the majority of the cases, these cases are very much alive before NCLTs. Pooja, do you think it's as simple as Sitesh is pointing out that, you have to hold 1 or 2 meetings only, and then, just tick box this requirement that the Supreme Court has now says is mandatory? Because as you pointed out to me in our offline conversation, that promoters are already sort of forming a line out of NCLTs to sort of make their case and agitate their case based on this Ruchi Soya ruling.
They have. I mean, we've actually seen cases where, at least in a lot of our cases, we've started getting notices from the directors. And these are cases where COCs have already approved the plans, and the plans are now pending before the adjudicating authority. And see, it really depends at what stage the plan really is before the adjudicating authority. We have already seen a fair bit of delay when it comes to actual passing of the order by the adjudicating authority. This is just going to further add on to that process. And even if we go back and let's say Committee of Creditors actually hear out the promoters or whatever they have to say on the resolution plan, it still gives a leeway to the promoters to then file an application and saying that it was not properly considered, or I should be heard, or I should not be heard. So far, we are not really seeing promoters very actively agitating against a resolution plan or one or the other ground. But the minute they get the resolution plan in their hand, they will find some ammunition to say something against the resolution plan. So to that extent, they will then have to be heard on what they have to say about the resolution plan. So far, perhaps they've not been agitating is because they don't have the resolution plan to agitate.
Sure. Sitesh, I do want to understand the purpose of this exercise. The way the Supreme Court has interpreted these various sections of the code seems like they believe that the erstwhile board can add considerable value to the resolution process. Is that what the law's intent is as you read it?
So undoubtedly, I think the erstwhile board of directors may have had a long innings in the company, seen the company's various facets of its functioning, and unless we start with the presumption that the board of directors were all cheats, and that is what caused the company to go downhill, we should in law have provide weight to their views. Now, how much weight is the Committee of Creditors' sole discretion? And ultimately, in commercial matters, the taste of the pudding is always in the eating. So if somebody challenges the resolution plan, he will have to come with a better one. And if he comes with a better one, the Committee of Creditors will be pleased with that. If he can't come with a better plan which pleases the committee of creditors, he may continue to agitate that his points were not considered by the committee of creditors, but that I don't think is going to prevail in any court. Ultimately, if somebody says that he was not heard, that the plan is a deficient one, he has to then come up and say, here is another plan which is better. And when that is there, always the courts will consider which is a better plan.
Well, they necessarily don't have to present a fresh plan, Sitesh. They can very well say that, look, the existing employees are not being treated fairly. These are the projects that, should require, due sort of focus in the resolution plan, and you're not doing justice. There can be, like Pooja pointed out, a variety of reasons within the resolution plan that these erstwhile directors should or can find to, agitate their case. But let me come to the issue of to what extent their inputs, should be considered by the COC. Pooja, in the Ruchi Soya case, the Supreme Court hasn't laid down any safeguards while interpreting the code the way it has. So is it sort of like a whole canvas now that these erstwhile directors have when it comes to their participation, and then probably further agitate their cases or their points before the courts?
See, like you said, the Ruchi Soya case doesn't really talk about what are the points they can possibly agitate in court about. The way I read Ruchi Soya, I think there are two basic reasons why the Supreme Court felt that you should give directors a right to participate. One is an information disclosure, where they say that the board of directors may have some valuable information to provide to the committee of creditors. And the second aspect they say is that the resolution plan itself may affect the promoters in a certain manner. For instance, it could talk about guarantees, it could talk about scaling down of the guarantees, or it could talk about keeping the guarantees alive. And because they are affected by those provisions of the resolution plan, they should be given some kind of voice or concern. As far as consideration of the plan itself is concerned, I think those are the areas where you're likely to see some amount of agitation or some issues being raised by the directors or the promoters who have given the guarantees and who are concerned about the fact that their guarantees are being kept alive or not being kept alive. But to be very honest, these concerns are already with the committee of creditors. It's not like the committee of creditors don't already know about these issues. It's just that they don't care about it. The fact that the promoters are agitating and saying that my guarantees should be kept alive or not be kept alive, etc., I don't really think that the committee of creditors would really have much to say about it or much to address that particular concern. So I don't really understand what practical purpose is really served by giving them a right to participate in these meetings. Yes, of course, if they have certain inputs about, okay, this was wrongly projected in the plan and this is not the right picture about the company, then yes, that's a different issue altogether. But as far as the other aspects of the plan is concerned, what the judgment really talks about is they should have a right to voice their concerns if it affects them. I'm not sure whether committee of creditors will really give much credence to that. And to that extent, whether even the NCLTs will really look at promoters' argument on those aspects.
Okay, so Sitesh, do you also believe that there, shouldn't be, any safeguards that are required? The Supreme Court hasn't really said as to how much say these promoters can have and how seriously the COC has to take their inputs.
So personally, I would say there is actually very limited room for mischief, given that the Supreme Court has already ruled in a number of judgments with regard to the role of the operational creditor, and also justified as to why operational creditors have been rightly denied a vote in the committee. So I think the primacy of the committee of creditors has already been sufficiently established by various rulings of the Supreme Court, and therefore there is limited role for mischief by the promoters to use this process to derail the resolution process. The committee of creditors has been asked to share the plan and take the inputs of the promoters. The commercial wisdom of the promoters has still got the primacy in the eyes of the court, and the logic why operational creditors are not heard or have limited role in the process of resolution, which the Supreme Court has pronounced, should also apply to the promoters and suspended board of directors, because they also don't have a right to vote in the meetings in the same way as operational creditors. I believe there is limited room for mischief here, given that the Supreme Court has expounded the law considerably, provided primacy to the Committee of Creditors, in that justified the preeminent role of the financial creditors and all that in various judgments. What would happen is that it may take some more time for some of the existing processes to go through this requirement of consulting the directors, the suspended directors, and then in certain cases the financial creditors could change their mind. In certain cases they may not, but ultimately it would all depend on whether there is commercial value being added. And hearing the directors, I don't think will only add value to the process. I don't think it will derail the process.
Okay, on your bit on that it's going to take only a little bit of more time, and you know this better than I do, that most of these lenders are losing huge amount of money with each day that the process is getting dragged on in courts. But let me now come to how the Ruchi Soya case will impact the Essar Steel matter. Pooja, based on the outcome in Ruchi Soya, can the COC be asked to reconsider all the plans after sharing them with the suspended board, and be asked to vote on it afresh?
See, my sense is, if you see if you just read the Ruchi Soya case, they have asked the Committee of Creditors to provide the resolution plans to the directors so that they can provide their inputs. So yes, it can definitely happen that they may say that the ArcelorMittal's plan, which has already been approved by the Committee of Creditors, should be provided to the erstwhile suspended directors, and let them provide comments on the resolution plan. I'm not sure if they will reopen everything all over again, because that's going to be a very messy outcome of the entire, a plan has already been approved. Let them all they should be saying is that let them have the copy of the plan and let them comment on it. But I guess another factor to be taken into account, at least in Essar cases, that you already have Numitel, which is agitating for its own plan. And the question then is that should the directors, who may possibly be aligned with the promoters, be given a right to comment on the resolution plan of ArcelorMittal when the converse right has not been given to ArcelorMittal? I think that's also going to be something that will come up before NCLT.
Okay, Sitesh, how are you looking in this?
So the issues around conflict of interest, the confidentiality.
Sure.
So
Sitesh,
I think if we follow the judgment, then in any pending case where the promoter has taken this ground of challenge already, that he was not given opportunity for hearing, it's not that he can now retrospectively start taking that ground based on this judgment. If he has taken this ground during the process, he will get the benefit of this judgment. And if the benefit of this judgment is given to the suspended board of directors, then the plans that have come before the Committee of Creditors would have to be given to these directors. They have to comment on it, and the COC will have to go through the process of voting again. So there are three requirements for that. One, the matter should not have attained finality, which means that NCLT should not have already decided the issue. Second, that a claim for the plan should have been made by the suspended directors during the process of insolvency. They can't start now getting wiser as a result of the judgment. And third, that there are plans which require they want to comment upon, the directors still want to comment upon even after the plan has been approved, and they seek to re-agitate the matter based on this judgment. I don't think you have to go back to the stage of calling for bids. I don't think that is the requirement. What is the requirement is whatever plans are there need to be commented upon by these directors, provided they have sought that opportunity on an earlier occasion before this judgment.
Well, these three directors in their application at least have pointed out that they did raise this issue with the resolution professional and the COC, that they weren't being given the notice of the COC meetings and they weren't, sort of given adequate participation opportunity in those meetings. But Sitesh, I'm not sure that this would be one of the grounds for these, erstwhile suspended board to clamp for this right now, because this right, as the Supreme Court has read the code, arises from the law itself, and the prerequisite, I'm not sure, is forthcoming in the Ruchi Soya case.
No, I think it's a part of the law itself, and a number of judgments of the Supreme Court which say that if you slept over your right at the start, you can't become wiser after a judgment comes of the Supreme Court and, claim a cause of action on that basis. But, it is still possible that, if large number of cases go to the Supreme Court may take a view that, they will only apply it prospectively. So, we'll have to still wait for that.
Sure, we'll have to wait for that. But if I can summarize your view in short, is that you think that in the Essar Steel case, all that the COC now needs to do is share the ArcelorMittal plan with these erstwhile board members, probably take their inputs, but they don't really have to account for them, and then they're good to go. Is that what your view is?
I would only, slightly change the last bit, that they have to account for it, but their decision may not change as a result.
Sure. Okay. All right. When I said account for it, I meant that incorporate it in the plan itself. Pooja, I'll give the last word to you. If you're going that far back, can, again, at this stage, new plans be entertained or existing plans be tweaked? Let's say Vedanta's plan, will that also need to be considered? Because these erstwhile directors might say that, hey, look, there was another resolution applicant who was in the fray. We don't know what that applicant offered. Where do you stop?
Yeah. Yeah. See, again, I agree with Sitesh that they are not likely to call for any new plans, and there's not going to be any consideration of anything new. ArcelorMittal's plan, according to me, will be given to the erstwhile directors to comment on it. I'm not sure whether they can also then say that, well, we don't think ArcelorMittal's plan is good. There was another resolution plan. Let us provide comments to that as well. That's something that they can also ask for. But ultimately, it's the COC to decide between the two plans which one they consider is better for them. And irrespective of the comments that the directors may have, it's irrelevant as far as the decision. They may consider it, they may minutize it in their committee meetings, but ultimately the decision will be based on their commercial wisdom. Just coming back to that point, Paswini, on parties who have not really agitated before, what has been happening so far in the resolution process is, in most cases, when the directors would be present for any meetings, they would be asked to step out. When anything relating to corporate insolvency resolution process in terms of resolution plans was discussed. So what started happening was that ultimately directors would not show up for subsequent meetings where a resolution plan was being considered. So that's something that they can definitely take up and say that we were denied that opportunity at that time. We were told that you cannot participate because of these reasons, and now that the Supreme Court has clarified that we can participate, we should be allowed to participate.
All right, Pooja and Sitesh,
which is essentially what is happening even in the SR case.
Okay, I'll leave it at that. But this case, as we've all figured out, keeps throwing up new twists and turns. The appellate tribunal, though, has directed the NCLT Ahmedabad bench to finalize or take a final view on the matter by February 11th. But we don't know with this new application whether that deadline would be met or not. Thank you both for joining us here on Insolvency Diaries, and thank you so much for watching.